Picture this. You arrest a black woman for a hit and run she didn't commit. Ignore her judicial ID, tell her she doesn't look like any judge you've ever seen in Minnesota. Handcuff her, hold her in detention. Then, the next day, you walk into court for an assault case against you and she's sitting on the bench. That's exactly what happened to Hennepin County Sheriff's deputies Justin Lumberfield and Edward Luke. And what they didn't know was that Judge Pamela Mitchell had just transferred to their district, a move so recent, even the court clerk hadn't updated the roster. If you are ready to see institutional racism taken down, like this video and drop a comment telling me where you're watching from. And if this is your first time here, hit that subscribe button right now, because you won't want to miss tomorrow's story of cops messing with the wrong people and finding out. Now let's see how a 52-year-old state magistrate judge ended up in handcuffs on I-94 and how two deputies ended up staring at her from the defendant's table the very next morning. Pamela Mitchell wasn't expecting to spend Saturday night in a holding cell. At 52 years old, the Minnesota State Magistrate Judge had spent 26 years building a reputation for precision, fairness, and unshakable composure. She presided over criminal cases, civil disputes, family court battles that left attorneys hollowed out by the end. She'd handled domestic violence hearings and sentencing for repeat offenders without flinching. But at 6:47 p.m. on a humid June evening, none of that mattered. The Midwest Children's Cancer Foundation Gala was scheduled to begin at 7:30 p.m. in downtown Minneapolis. Pamela had been looking forward to it for weeks, not for the speeches or the recognition, but for the families. The parents who'd spent months in hospital rooms, the siblings who'd learned medical terminology before they learned algebra, the children who smiled through exhaustion, their resilience a kind of grace Pamela couldn't name but recognized in her bones. She'd chosen her outfit carefully that morning, a tailored navy blazer over a cream silk blouse, slim black trousers, low heels suitable for standing through cocktail hour. Her hair, usually pinned back for court, fell in soft waves past her shoulders. She wore her mother's pearl earrings, small, elegant, the kind that didn't demand attention. She looked exactly like what she was, a professional woman heading to an event that mattered. The briefcase on her passenger seat held her judicial credentials, a handwritten card for one of the honorees, and a check she'd written that morning. Pamela had grown up watching her parents stretch every dollar, had put herself through law school on scholarships and night shifts at the university library. Money still felt tenuous to her, even now. But children fighting cancer that was worth stretching for. I-94 West stretched ahead, 3 lanes of rush-hour traffic crawling toward the city. Pamela glanced at the dashboard clock. 6:49 p.m. She'd make it. Barely. But she'd make it. The memory surfaced without warning. She'd been 9 years old, sitting in the back of her father's station wagon after a traffic stop on this same highway. The officer had made her father step out, made him place his hands on the hood, made him explain why he was driving through a predominantly white suburb. Pamela had watched her father's shoulders tighten, his voice steady even as humiliation burned in the rigid set of his jaw. Afterward, driving home in silence, he'd caught her eye in the rearview mirror. "You're going to college, baby girl. You're going to make things different." Pamela had kept that promise. First in her family to earn a law degree, public defender for 7 years, assistant district attorney for 5 more, magistrate judge at 46. Appointed after a unanimous recommendation from the Judicial Nominating Commission. She'd made things different. She'd made her father proud before he passed 3 years ago. The blue lights flashed in her rearview mirror at 6:52 p.m. Pamela's heart didn't race. She'd been pulled over twice in her life, both times for minor infractions she'd corrected immediately. She signaled, eased onto the shoulder, and placed both hands on the steering wheel in plain view. The traffic beside her slowed, drivers craning their necks to watch. 2 deputies emerged from the Hennepin County Sheriff's patrol vehicle. The first, tall, broad-shouldered, mid-30s, approached her driver's side with a flashlight, though daylight still hung heavy in the June sky. The second, younger and wiry, circled to the passenger side, his own flashlight scanning the interior of her sedan. The first deputy tapped on her window with 2 knuckles. Pamela lowered it smoothly. His name tag read, Lumberfield. He didn't smile. Pamela kept her voice calm, polite. She explained that she was heading to the Children's Cancer fundraiser downtown, that she was running late, that she hadn't been speeding. She gestured toward her briefcase. Lumberfield's flashlight beam landed on her face, then swept across the passenger seat. He told her they were pursuing a bolo, a be on the lookout for a hit-and-run driver, dark sedan, female driver, vague description. He said her vehicle matched. Pamela reached slowly for her briefcase, extracting her judicial credentials with deliberate care. She held the ID up where both deputies could see it clearly. The embossed seal of the Minnesota Judiciary caught the fading sunlight. Lumberfield studied the ID without touching it. His expression didn't shift. He said he'd need to verify it, run it through the system, standard procedure. The second deputy, Luke, according to his name tag, leaned down to peer through the passenger window. His gaze traveled from Pamela's face to the briefcase, then back. He said something, under his breath, to Lumberfield. Then louder, so Pamela could hear. She didn't look like any judge around Minnesota he'd ever seen. The words landed with the weight of stones. Pamela's hands tightened on the steering wheel. She kept her voice level, professional. She pointed out that his remark was inappropriate and unrelated to the traffic stop. She said she was willing to wait while they verified her credentials, but she expected to be treated with the respect her position and any citizen deserved. Lumberfield's jaw tightened. He told her to step out of the vehicle. Pamela complied. She stood beside her car, aware of the phones now raised in passing vehicles, of the way Luke's hand hovered near his belt, of the way Lumberfield's posture had shifted from procedural to defensive. She asked again about the bolo. What, specifically, matched? Make, model, license plate? Lumberfield said she was causing unrest, interfering with an investigation. Pamela began to respond, calm, measured, the voice she used in courtrooms when attorneys tested her patience, but Luke had already moved behind her. The handcuffs clicked around her wrists before she could process what was happening. Someone in a passing car shouted. Another driver slowed, filming openly. Pamela felt the metal bite into her skin, felt the briefcase slip from her grasp as Lumberfield caught her elbow and guided her firmly, not gently, toward the patrol vehicle. She asked what she was being charged with. Lumberfield didn't answer. The back seat of the cruiser smelled like sweat and industrial cleaner. Pamela sat with her hands cuffed behind her, the position forcing her shoulders forward at an unnatural angle. Through the partition, she watched Lumberfield and Luke confer by her sedan, their voices muffled. Luke gestured toward the highway, toward the gathering phones. Lumberfield shook his head, said something sharp. The engine started. The cruiser pulled back onto I-94, heading not toward downtown Minneapolis, but west, toward the Hennepin County Sheriff's Office substation. Pamela stared out the window as the city skyline receded. The gala would start in 38 minutes. The families would gather. The speeches would begin. The children would smile through their exhaustion. She wouldn't be there. She'd spent her career fighting for fairness. She'd sat on the bench and weighed evidence, cross-examined biases, ensured every person before her, regardless of background, received equal treatment under the law. She believed, deeply, that the system could work if good people held it accountable. Now she sat in the back of a police cruiser, hands cuffed, heading toward a holding cell, because 2 deputies had decided she didn't look like a judge. The booking process took 43 minutes. Fingerprints pressed onto a scanner, mugshot taken under fluorescent lights that bleached the color from her face. Personal belongings cataloged and sealed in a plastic bag. Pearl earrings, wedding ring, phone, briefcase, the check she'd written that morning for the foundation. An officer at the desk, older, gray-haired, name tag reading Kowalski, glanced at the intake form, then at Pamela. He asked Lumberfield if they'd verified her credentials. Lumberfield said they'd run it through the system. The credentials checked out. But she'd been uncooperative, argumentative, interfering with official duties. Kowalski's gaze lingered on Pamela for a long moment. He looked like he wanted to say something. Instead, he initialed the form and slid it back across the counter. Pamela was led to a holding cell 8 feet by 6, concrete block walls, a metal bench bolted to the floor. The door clanged shut. The lock turned. She sat on the bench, still in her blazer and cream blouse, her mother's earrings already confiscated. The cell smelled like bleach and desperation. Somewhere down the corridor, another detainee shouted something incoherent. The fluorescent lights hummed overhead, relentless. Pamela didn't cry. She'd learned early in her legal career that tears were a luxury she couldn't afford in spaces where every reaction was cataloged, every emotion weaponized. But sitting alone in that cell, watching the minutes crawl past on the wall clock visible through the bars, She felt something crack open inside her chest. The gala would be over by now. The children would have gone home, clutching their certificates and gifts, their parents grateful for one evening of normalcy. She'd missed it. All of it. Hours passed. The lights never dimmed. A tray of food arrived through a slot in the door, something beige and shapeless, a carton of milk, a plastic spoon. Pamela didn't touch it. At 11:17 p.m., Kowalski appeared outside the cell. He told her bond had been posted. She was free to go. Pamela stood slowly, her body stiff from hours on the metal bench. She collected her belongings at the front desk, signing forms with hands that felt disconnected from her body. Her phone showed 17 missed calls, 9 voicemails. She didn't listen to them. The night air was cool when she stepped outside. Her sedan had been towed to the impound lot. She'd need to retrieve it tomorrow. For now, she called a rideshare and waited under the fluorescent glow of the station's exterior lights. The driver didn't ask questions. Pamela sat in the back seat, watching the dark stretch of highway roll past, and thought about her father's hands on the hood of that station wagon 30 years ago. She thought about the children at the gala she'd missed. She thought about Lumberfield's skeptical stare and Luke's casual cruelty. She thought about Monday morning, when the Hennepin County Courthouse would open its doors and the week's docket would begin. And for the first time since the handcuffs had clicked around her wrists, Pamela Mitchell smiled. Her townhouse in South Minneapolis smelled stale when she opened the door. Mail scattered across the entryway floor. The coffee maker she'd set to auto-brew Saturday morning had long since shut itself off, leaving cold sludge in the carafe. Pamela dropped her briefcase by the door and walked directly to the shower. The hot water scalded her skin. She stood under the spray until it ran lukewarm, washing away the holding cell's bleach smell, the residue of humiliation that clung to her like smoke. When she finally stepped out, wrapped in her robe, her phone was ringing. 17 more missed calls. Messages from the foundation's director, apologizing for her absence, hoping everything was all right, texts from colleagues asking if she'd heard about the reassignment, an email from the court administrator confirming what Pamela had temporarily forgotten. Her transfer to the new district courtroom had been finalized Friday afternoon, effective Monday morning. She'd be presiding over cases in Hennepin County's 4th Judicial District, including pending matters transferred from Judge Randolph's docket after his retirement. Pamela sat on the edge of her bed, phone in hand, and scrolled through the case list. Pending criminal matters, civil disputes, a handful of preliminary hearings, and there, scheduled for 10 a.m., Monday morning, State of Minnesota v. Justin Lumberfield and Edward Luke. Assault charges stemming from an incident during an arrest 6 months prior. Witnesses lined up. Evidence logged. Attorneys of record already filed. Pamela set the phone down carefully. Her hands didn't shake. Her pulse didn't quicken. She simply sat there, absorbing the information with the methodical calm of someone who'd spent decades weighing evidence. The system had handed her an opportunity. Not revenge. She didn't traffic in revenge, but accountability. The real kind. The kind that mattered. She thought about her mother, who'd worked double shifts as a nurse's aide to keep the lights on after Pamela's father died. About the law school professors who told her she was too soft-spoken for trial work, that she should consider corporate law instead. About every courtroom where she'd had to prove herself twice over, every case where her rulings were questioned not on merit but on assumption. She'd built her career on proving that the system could work. That impartiality, applied without fear or favor, could deliver justice. Monday morning would test that belief. 8 miles away, in the Hennepin County Sheriff's Office substation break room, Justin Lumberfield poured his 3rd cup of coffee and replayed Saturday Night's Stop for the 4th time that morning. Edward Luke sat across from him, scrolling through his phone without looking up. The shift had been quiet. 2 DUIs, 1 domestic disturbance, routine paperwork. The Mitchell arrest hadn't been mentioned in the log beyond the standard intake notation. No complaints filed, no supervisor inquiries, just another stop in a long list of stops. Lumberfield dumped sugar into his coffee, stirred it with a plastic stick. He told Luke they'd handled it correctly. The bolo had been legitimate. Her attitude had escalated the situation. The credentials had checked out eventually, but procedure required verification. Everything by the book. Luke grunted agreement without looking up from his phone. They had court at 10 a.m. The assault case, some protester claiming excessive force during a demonstration last winter. Luke had pushed the guy back when he'd gotten too close to the police line. The guy had fallen, hit his head, made a scene. Standard crowd control scenario blown out of proportion by activists with cameras. Lumberfield finished his coffee. He wasn't worried. The department's attorney was solid. The evidence was thin. The charges would be dismissed or reduced to nothing. They'd done this dance before. He clocked out at 8:47 a.m., drove home, showered, changed into the dark suit and tie required for court appearances. Luke texted him at 9:30 a.m., meeting at the courthouse entrance at 9:45. Don't be late. Lumberfield wasn't late. The Hennepin County Courthouse rose 7 stories, its limestone facade weathered by decades of Minnesota winters. Lumberfield and Luke entered through the security checkpoint, badges clipped to their belts, moving with the easy confidence of men who spent half their professional lives in these halls. They took the elevator to the 4th floor. Courtroom 4C. Their attorney, a sharp-eyed woman named Patricia Voss, met them outside, briefcase in hand. She ran through the morning's procedure. Preliminary hearing, motions to dismiss, standard defense arguments. She expected the judge to rule in their favor. Worst case, the matter would proceed to trial, but that was months away. Lumberfield nodded. Luke checked his phone one more time before they entered. The courtroom smelled like old wood and floor polish. The gallery was half full, a few reporters, some activists with matching t-shirts, the plaintiff and his attorney seated at the prosecution table. Lumberfield and Luke took their seats at the defense table, Voss between them, arranging files with practiced efficiency. At exactly 10 a.m., the bailiff called the room to order. The side door opened. Pamela Mitchell stepped through in full judicial robes, black fabric falling in clean lines from her shoulders, her hair pinned back in the neat bun she wore every day on the bench. She carried a file folder under one arm, her reading glasses perched on her nose. She crossed to the bench without hurrying. Saturday arranged her materials, looked up. Her gaze landed on Lumberfield first, then Luke. The recognition was instant, mutual, undeniable. Lumberfield's coffee turned to acid in his stomach. Luke's face drained of color. Voss glanced between them, confused, whispering a question neither man could answer because their mouths had gone dry. Pamela adjusted her glasses. Her expression didn't change, calm, composed, professional. She opened the file, reviewed the case notation, and spoke in the clear, measured tone she used for every proceeding. She disclosed, for the record, that she had a prior interaction with the defendants. A traffic stop. Saturday evening. She'd been detained, released on bond. The matter was unrelated to the current case, but judicial ethics required transparency. Whispers erupted through the gallery. Reporters leaned forward, pens moving. The activists exchanged glances, eyes wide. Pamela continued without pause. Given the prior interaction, she was recusing herself from the case to avoid any appearance of bias or conflict of interest. Judge Thomas Brennan would assume the matter effective immediately. The hearing would proceed as scheduled under his jurisdiction. She gathered her files, stood. Her gaze swept across the courtroom, not lingering on Lumberfield or Luke, not acknowledging the stunned silence, not offering anything beyond procedural courtesy. But just before she turned toward the side door, her eyes met Lumberfield's one last time. The look held for less than 2 seconds. It was enough. The door closed behind her with a soft click. The courtroom remained silent for a beat too long. Then the bailiff called a 15-minute recess, while Judge Brennan was summoned. Voss turned to Lumberfield and Luke, her voice low and urgent, demanding to know what the hell had just happened. Lumberfield couldn't answer. His mind was racing, replaying Saturday night's stop, frame by frame, cataloging every word, every gesture, every decision that had seemed routine at the time, but now felt like evidence stacking against him. Luke's hands were shaking. He pressed them flat against the table, trying to steady himself. He thought about the comment he'd made, "Doesn't look like any judge around Minnesota I've ever seen," and realized, with creeping horror, that it had probably been recorded. Body cams, dashboard cams, ohms from passing cars. Judge Brennan entered 20 minutes later, elderly and methodical, calling the hearing to order with the disinterested efficiency of someone who'd presided over 10,000 cases and had 10,000 more to go. He reviewed the motions, heard the arguments, denied the motion to dismiss. The case would proceed to trial. Discovery would continue. Both parties would submit witness lists by end of month. Lumberfield barely heard the words. Luke stared at the table, his jaw clenched tight. They left the courthouse at 11:47 a.m. Voss trailing behind them, still asking questions they couldn't answer. Outside, The June sun felt too bright, the air too heavy. Lumberfield pulled out his phone. Luke did the same. They needed to talk. Privately, immediately. Because the woman they dismissed, mocked, and detained was a sitting state magistrate judge. And on Monday morning, she'd held their futures in her hands and chosen to let someone else decide. That should have been a relief. It wasn't, because Pamela Mitchell had also chosen to disclose everything on the record, in open court, in front of reporters and activists and attorneys who would dissect every word, every implication, every angle. She'd recused herself from judging them directly, but she'd ensured the world would be watching when someone else did. The realization settled over Lumberfield and Luke as they drove back to the station in separate vehicles, phones buzzing with messages from colleagues who'd already heard whispers, questions piling up faster than they could answer. Judge Brennan's ruling echoed in their minds. Trial. Discovery. Witness lists. Everything would be examined now. Everything. And somewhere across the city, Pamela Mitchell was returning to her chambers, filing her recusal paperwork and preparing for the week ahead with the same methodical precision she brought to every case. Justice, she'd learned long ago, wasn't about spectacle. It was about method, procedure, letting the system work the way it was designed. But sometimes, she thought as she signed the final form, the system needed a small nudge in the right direction. She placed the paperwork in her outbox and turned her attention to Tuesday's docket. 23 cases, each one deserving her full attention. The work, as always, continued. The Hennepin County Sheriff's Office substation felt smaller than usual when Lumberfield and Luke returned Monday afternoon. The hallway seemed too narrow, the fluorescent lights too harsh. Every colleague's glance waited with unspoken questions. They retreated to the report-writing room, a cramped space with 4 desks, 3 computers, and filing cabinets that hadn't been organized since the previous decade. Luke closed the door. Lumberfield pulled the blinds. Neither man sat. Luke spoke first, his voice low and tight. He wanted to know what they were going to do. The judge had disclosed everything. On the record, in open court, which meant the arrest report would be scrutinized, the body cam footage would be reviewed, every detail of Saturday night's stop would be examined by attorneys looking for ammunition. Lumberfield's jaw tightened. He told Luke to calm down. The stop had been legitimate. The bolo was real. They'd followed procedure. Mitchell had been argumentative, uncooperative. Everything was documented. They just needed to make sure the documentation was airtight. Luke stared at him. Airtight. Right. Lumberfield moved to the nearest computer, logged in with hands that were steadier than they should have been. He pulled up the arrest report he'd filed Sunday morning, standard template, standard language, standard justifications, traffic stop, bolo match, verbal interference, detention necessary to maintain order. It read clean, professional, by the book. Except for the part where the detainee was a sitting state magistrate judge and one of them had told her she didn't look like any judge in Minnesota. Luke leaned over Lumberfield's shoulder, reading the screen. He asked about the body cam footage. Lumberfield said it was automatically uploaded to the server, time-stamped, stored, unless they accessed it for evidence review. They could review it, check for anything problematic, make sure the audio was clear. Luke's eyes narrowed. Make sure. Right. Lumberfield opened the body cam archive, entered his credentials, and pulled up Saturday night's footage. 2 files. His camera, Luke's camera. He clicked play on his own first. The footage rolled. Blue lights, highway traffic, Mitchell's sedan pulling over, Lumberfield's approach, the flashlight beam on her face. Her voice, calm and polite, explaining about the fundraiser, the judicial ID held up for verification. Then Luke's voice, slightly off camera. Doesn't look like any judge around Minnesota I've ever seen. The words landed with perfect clarity. No ambiguity. No room for interpretation. Lumberfield closed the file. Opened Luke's camera. Same scene, different angle. The comment was even clearer from this perspective, Luke's face visible in the frame's edge, his expression dismissive. Luke stepped back from the computer. He ran both hands through his hair, exhaled slowly. He asked what they were going to do. Again, Lumberfield didn't answer immediately. His mind was working through possibilities, scenarios, outcomes. The footage was damning. Not criminal, nothing they'd done violated protocol in any prosecutable sense. But optics mattered. Context mattered. A black judge detained after presenting credentials, after a deputy made a comment that could easily be framed as racially motivated. The assault case would draw attention now. Reporters would dig, activists would amplify, and if anyone requested the body cam footage through public records, Lumberfield minimized the video file. He told Luke they needed to write supplemental reports, clarify the sequence of events, emphasize the BOLO, the verification process, the standard procedures they'd followed, document everything before anyone started asking questions. Luke asked if they should talk to the union rep. Lumberfield shook his head. Not yet. Union involvement meant acknowledging a problem. Right now, there was no problem. Just a routine stop that happened to involve someone with a title. They'd handled it professionally. The supplemental reports would demonstrate that. Luke didn't look convinced, but he nodded anyway. They spent the next 40 minutes drafting supplemental documentation. Lumberfield's report detailed the BOLO parameters, the vehicle match, the need for credential verification due to sophisticated fraud schemes. He noted Mitchell's cooperation during the booking process, the lack of resistance, the standard detention pending bond. He did not mention Luke's comment. Neither did Luke's own supplemental report. Lumberfield saved both files to the shared drive. He attached them to the original arrest report, sent copies to the watch commander's administrative folder. Standard procedure. Everything documented. Everything justified. He logged out, closed the browser, stood. That's when he realized his mistake. The email notification had already gone out. Automatic system alert. Supplemental reports filed for case number 24HC8847. Standard distribution. Watch commander, shift supervisor, administrative review. And because he'd been rushing, because his hands had been less steady than he'd thought, because the drop-down menu had defaulted to all supervisors, Chief Deputy Roland Hayes, who oversaw internal affairs, Lumberfield's stomach dropped. Luke saw his expression, asked what was wrong. Lumberfield pulled the email back up, checked the distribution list, confirmed what he'd already suspected. Hayes would see the supplemental reports. Hayes would compare them to the original arrest report. Hayes, who had a reputation for meticulousness and a personal interest in rooting out liability issues, would wonder why two deputies felt the need to file additional documentation for a routine traffic stop. And Hayes would pull the body cam footage to verify their accounts. Luke leaned against the desk, his face pale. He asked if they could delete the email. Lumberfield shook his head. System logs tracked everything. Deletion would raise more flags than the original mistake. They were committed now. The reports were filed. The email was sent. Hayes would review the material, probably within 48 hours, and make whatever determination he made. All they could do was wait. Luke asked again about the union rep. This time, Lumberfield didn't argue. Across the city, in a home office lined with legal texts and framed commendations, Pamela Mitchell sat at her desk reviewing her own options. The recusal had been necessary, ethically required, but disclosure had been a choice, and she'd chosen transparency. Let the record reflect what happened. Let the public see. Let the system respond. She'd contacted her attorney that morning, David Rashad, civil rights specialist, 20 years of experience litigating police misconduct cases. She'd known him since law school, trusted his judgment, respected his restraint. He didn't chase headlines. He built cases. Rashad had listened to her account without interrupting. Then he'd asked 3 questions. Did she want to file a formal complaint? Did she want to pursue civil litigation? Did she want to let it go? Pamela had answered the 3rd question first. No. She would not let it go. She'd spent her career enforcing accountability. She'd sentenced defendants who'd made mistakes, who'd let bias guide their decisions, who'd abused the authority granted to them. She'd done so impartially, dispassionately, without personal investment. This time, the system had failed her, and if she didn't hold it accountable, who would? Rashad had advised patience. Let the assault case proceed. Monitor how the department responded to the disclosed arrest. Document everything. If patterns emerged, if Lumberfield and Luke had histories of similar incidents, if the department tried to bury the matter, then they'd have grounds for a comprehensive civil rights lawsuit. But rushing would weaken the case. The strongest litigation came from meticulous preparation. Pamela had agreed. She would wait, document, prepare. But she would not be silent. At the substation, a junior deputy named Angela Torres, sat in the break room nursing lukewarm coffee and scrolling through the internal case log. She'd overheard Lumberfield and Luke in the report writing room earlier, fragments of conversation through the closed door, voices too low to parse but tense enough to notice. Torres had been with the department for 18 months, long enough to recognize when senior deputies were worried, long enough to know that worry usually meant mistakes. She pulled up the case log, found the entry for Saturday night, read the arrest report, noted the detainee's name, Pamela Mitchell, title, State Magistrate Judge. Torres blinked, set down her coffee. Read the report again. Then she pulled up the body cam footage request form, filled it in, submitted it. The system would notify her when the files were available for review, standard internal access, no special permissions required. She didn't know yet what she'd find, but instinct, honed through 18 months of watching senior deputies cover for each other, told her it would matter. By Tuesday morning, 3 separate investigations had begun without anyone officially announcing them. Chief Deputy Hayes had reviewed the supplemental reports, pulled the body cam footage, watched Luke's comment play 3 times before forwarding the matter to Internal Affairs with a terse note, review for potential bias violation. Angela Torres had received her body cam footage access, watched both cameras, taken notes, screenshot the most problematic exchanges. She hadn't decided yet what to do with them, but she'd started a file. And David Rashad had begun pulling records. Court cases involving Lumberfield and Luke. Arrest statistics. Complaints filed and dismissed. He was building a pattern map, looking for connections, waiting for the moment when documentation transformed into evidence. None of these 3 people knew about the others yet, but the threads were already intersecting, weaving toward a conclusion none of them could fully predict. Justice, Pamela thought as she prepared for Wednesday's docket, wasn't a single moment. It was a process. Slow, methodical, built on procedures and protocols that most people never saw. But when the process worked, when documentation met scrutiny, when bias met accountability, when power met consequence, the results could reshape systems. She just had to wait for the threads to tighten and trust that they would. The formal complaint arrived at the Hennepin County Sheriff's Office on a Thursday morning, 3 weeks after Pamela Mitchell's arrest. Hand-delivered by a process server, signed for by the administrative assistant, who normally handled parking citations and records requests. The envelope contained 47 pages. Civil rights violation lawsuit, false arrest, racial discrimination, unlawful detention. Filed in Federal District Court under 42 U.S.C. Section 1983, with plaintiff Pamela Mitchell, represented by attorney David Rashad. By noon, the complaint had been forwarded to the county attorney's office. By 2 p.m., it had landed on the desk of Sheriff Thomas Gunderson, who read it twice before calling an emergency meeting with his executive staff. By 4 p.m., Lumberfield and Luke had been placed on administrative leave pending investigation. The complaint was methodical. It outlined the traffic stop sequence minute by minute, citing body cam timestamps, transcripts of recorded exchanges, witness statements from passing motorists who'd filmed portions of the incident. It noted the Bolo's vague parameters, dark sedan, female driver, and documented 17 other vehicles matching that description that had passed the same stretch of highway without being stopped. It presented Luke's comment in full. Doesn't look like any judge around Minnesota I've ever seen. Audio analysis confirmed the words, transcribed verbatim. Context made the implication clear. It detailed the detention, the booking process, the holding cell, the missed fundraiser for child cancer support, the emotional distress of being treated as a criminal despite presenting valid judicial credentials, and it included discovery requests. Comprehensive, sweeping. Every arrest report filed by Lumberfield and Luke over the past 5 years. All body cam footage. Internal communications. Training records. Disciplinary history. Complaints filed and dismissed. The county attorney assigned the case to external counsel, a downtown firm specializing in municipal defense. They would handle depositions, motions, trial preparation, standard procedure for litigation involving law enforcement. But this wasn't standard litigation. The plaintiff was a sitting state magistrate judge. The allegations involved racial bias documented on video, and the media attention had already begun. The pretrial hearing took place 8 weeks later in federal court, Judge Lawrence Kincaid presiding. The courtroom was packed, reporters in the gallery, activists wearing t-shirts that read "ACT Accountability Now," and a handful of sheriff's deputies in plain clothes watching silently from the back rows. Pamela sat at the plaintiff's table beside Rashad, dressed in a charcoal suit, her expression neutral. She'd recused herself from all active cases during the litigation to avoid any appearance of conflict, her caseload temporarily redistributed among other magistrates. Across the aisle, Lumberfield and Luke sat with their attorney, a silver-haired litigator named Charles Whitman who'd spent 30 years defending police departments. His strategy was clear from his opening motion: challenge the standing, argue qualified immunity, dismiss before discovery could expose anything damaging. Judge Kincaid denied the motion to dismiss. Discovery would proceed. Rashad requested expedited production of documents. The defense objected, citing volume and sensitivity. Kincaid split the difference. Priority documents within 30 days. Remaining materials within 60. The first batch arrived exactly 30 days later. 2,000 pages of arrest reports, incident logs, internal memos. Rashad's paralegal team spent 70 hours cataloging and cross-referencing. Patterns emerged. Lumberfield and Luke had conducted 847 traffic stops over a 4-year period. Of those, 394 involved minority drivers, 46, 5% of the total, despite minorities representing 23% of the county's driving population. Of the arrests made during those stops, 67% involved Black or Hispanic individuals. 38 complaints had been filed against the deputies in that time frame. 34 had been dismissed as unsubstantiated. 4 had resulted in written reprimands, later expunged from their files. The body cam footage told a more detailed story. Rashad's team isolated 12 stops, where deputies made comments similar to Luke's remarks about appearance, demeanor, credibility that correlated with the driver's race. In 6 cases, the drivers had been detained, despite presenting valid identification. In 4 cases, the drivers had filed complaints that were later dismissed. One driver was a doctor, another was a high school principal, a third was a county social worker. All of them had been treated as suspects first, citizens second. Rashad compiled the evidence into a supplemental brief. 53 pages, charts, statistical analysis, expert testimony from a criminologist specializing in racial bias in policing. The brief landed like a bomb. The whistleblowers emerged during the discovery phase, anonymously at first. Angela Torres had kept her file private for weeks, uncertain what to do with it. But when the lawsuit went public, when she saw the patterns Rashad had documented, she realized her silence made her complicit. She contacted Internal Affairs, requested confidentiality, provided her screenshots, her notes, her observations of Lumberfield and Luke's behavior in the months since the arrest. She also mentioned something she'd overheard, a conversation in the locker room about quotas not official policy, but an unspoken expectation to maintain certain arrest numbers, particularly in high-traffic areas where stops were less likely to draw scrutiny. Internal Affairs opened a parallel investigation. Within days, 3 other deputies came forward, also requesting anonymity. They corroborated Torres's account. They described a departmental culture that rewarded aggressive enforcement, that measured success in numbers rather than community trust, that tacitly encouraged stops targeting high-probability suspects. One deputy provided emails. Another provided a supervisor's informal log handwritten notes, tracking monthly arrest totals by deputy, with stars beside names that exceeded expectations. Lumberfield and Luke's names had stars for 36 consecutive months. The depositions began in October. Lumberfield went first. Rashad questioned him for 6 hours across 2 days. The transcript ran 347 pages. Lumberfield maintained that the stop had been legitimate, the detention necessary, the procedures followed correctly. He couldn't explain the statistical disparities. He denied any racial motivation. He called Luke's comment unfortunate phrasing, but insisted it hadn't influenced the decision to detain Mitchell. When Rashad played the body cam footage, Luke's comment, Lumberfield's lack of response, the decision to escalate, Lumberfield said he'd been focused on officer safety. He said Mitchell's demeanor had concerned him. He said everything looked different in hindsight. Rashad let the silence hang after that answer. Let Lumberfield's own words create the implication. Luke's deposition was shorter, 4 hours. He was quieter than Lumberfield, more careful with his words, but when Rashad asked him to explain what he'd meant by the comment, Luke hesitated too long. His answer, something about not recognizing her from courthouse interactions, rang hollow even in transcript form. Rashad asked if Luke had interactions with other judges. Luke said yes. Rashad asked if he'd ever made similar comments about white judges. Luke said no, but clarified that white judges usually looked more formal. Rashad didn't follow up. He didn't need to. The answer would play perfectly in front of a jury. By December, the case had expanded beyond Lumberfield and Luke. The discovery materials had exposed systemic issues, the quota system, the training deficiencies, the complaint dismissal process that protected deputies rather than investigating allegations. 3 additional plaintiffs joined the lawsuit, represented by Rashad, the doctor, the principal, the social worker. All had been stopped by Lumberfield or Luke. All had been treated with suspicion despite valid credentials. All had filed complaints that disappeared into administrative review. The media coverage intensified. Local news ran segments on the enforcement log Torres had exposed. National outlets picked up the story, framing it as systemic bias in suburban policing. Community groups organized protests outside the sheriff's office, demanding accountability, demanding reform. Sheriff Gunderson held a press conference. He announced mandatory bias training for all deputies. He promised an independent review of arrest patterns. He said the department took these allegations seriously. But he didn't suspend Lumberfield or Luke. He didn't acknowledge the quota system. He called the statistical patterns concerning but not conclusive. Rashad responded with a motion to add the county and the sheriff's office as defendants under supervisory liability. Judge Kincaid granted it. The trial date was set for March. In her chambers, Pamela reviewed Rashad's case materials each evening after her temporary caseload was complete. She read the depositions, studied the statistical analyses, absorbed the testimonies from other plaintiffs who'd experienced what she'd experienced. She thought about her father's hands on that station wagon hood, about her mother's double shifts, about the promise she'd made to make the system work. This was the system working. Slowly, methodically, through documentation and discovery, through procedures designed to surface truth even when institutions resisted. It wasn't satisfying in the way revenge would be. It wasn't immediate, but it was real. And reality, Pamela had learned, was what lasted after the spectacle faded. Luke resigned in January, 2 months before trial. No public statement, no press conference, just a brief letter to Gunderson citing personal reasons and the need to pursue other opportunities. Privately, he'd been attending counseling sessions twice weekly. His attorney had advised him that resignation might demonstrate remorse, might reduce damages, might give him a path forward. Luke didn't know if he believed in paths forward anymore. But he couldn't keep showing up to work, couldn't keep pretending the uniform didn't feel like evidence now. Lumberfield refused to resign. He told his union rep that he'd done nothing wrong. He said the lawsuit was political theater, activist manipulation, a judge with a grudge weaponizing the system. His confidence was eroding, though. He'd stopped sleeping through the night. His wife had moved out in November. His friends at the department had stopped texting. The trial was 6 weeks away. And somewhere in Minneapolis, Pamela Mitchell was preparing to testify about the night she'd sat in a holding cell, missing a fundraiser for children with cancer, because 2 deputies had decided she didn't look like a judge. The system was working, slowly, but working. The trial began on a cold March morning. Snow still clinging to the courthouse steps, the sky heavy with the promise of more to come. The federal courthouse in downtown Minneapolis had seen hundreds of civil rights cases over the decades, but this one drew crowds unlike anything the marshals could remember. Reporters lined up before dawn. Activists held vigil with signs and candles. Inside, the gallery filled within minutes. Standing room only, spectators pressed against the back wall. Judge Lawrence Kincaid called the courtroom to order at 9:02 a.m. Jury selected the previous week, 12 citizens, 7 women, 5 men, diverse in age and background, sworn to impartiality. They sat in the box with the careful attention of people who understood the weight of what they were about to hear. Rashad's opening statement was precise. 23 minutes outlining the evidence, the patterns, the systemic failures that had allowed bias to flourish unchecked. He told Pamela's story, the traffic stop, the comment, the detention, the missed fundraiser. He placed it in context, 17 other stops, 38 dismissed complaints, a quota system that incentivized arrests over community trust. He closed with a question. What happens when the people sworn to protect us decide who deserves protection based on how they look? The defense attorney, Whitman, countered with reasonableness. He acknowledged the optics were unfortunate. He expressed regret for any distress caused. But he emphasized split-second decisions, officer safety, the challenges of law enforcement in an era of heightened scrutiny. He painted Lumberfield and Luke as dedicated public servants caught in a moment of imperfect judgment, not systemic racism. He asked the jury to see the human beings behind the badges, not the narrative activists wanted to impose. The testimony began on day 2. Pamela took the stand mid-morning after Rashad had methodically laid the foundation with documentary evidence and expert witnesses. She wore a navy suit, minimal jewelry, her hair pulled back. She looked exactly like what she was, a professional who'd spent decades in courtrooms. Rashad walked her through the evening of her arrest, the fundraiser, the blue lights, the deputy's approach, the judicial ID, Luke's comment. Pamela's voice remained steady. She described the handcuffs, the holding cell, the cold metal bench. She talked about the children at the fundraiser she'd never met, the check she'd written that sat in a plastic evidence bag instead of supporting cancer research. She didn't cry, didn't raise her voice, didn't perform grief or outrage. She simply testified, clearly, methodically, letting the facts speak. Whitman's cross-examination tried to establish that she'd been uncooperative, that her tone had escalated the situation, that reasonable officers could have interpreted her behavior as suspicious. He suggested that focusing on the fundraiser implied she expected special treatment. Pamela answered each question without defensiveness. She acknowledged she'd been firm. She said she'd expected to be treated with the dignity any citizen deserved. She noted that presenting valid judicial credentials wasn't asking for special treatment, it was providing identification as requested. When Whitman asked if she held any personal animosity toward deputies Lumberfield and Luke, Pamela paused, looked directly at the jury. She said she held animosity toward systems that allowed bias to operate without accountability, toward training that prioritized quotas over community, toward complaint processes that protected officers instead of investigating allegations, but toward 2 men who'd made bad decisions. No. She felt disappointment, because they'd been given authority and had failed to use it responsibly. The jury absorbed this without visible reaction, but several jurors took notes. The other plaintiffs testified over the next 3 days. Dr. Raymond Cole, stopped while driving home from the hospital, detained for 90 minutes despite his medical credentials. Principal Linda Hayes, pulled over with her teenage daughter in the car, subjected to vehicle search while her daughter watched. Social worker Marcus Thompson, arrested for obstruction after questioning why his registration check was taking 45 minutes. Each story followed similar patterns. Each body cam footage showed similar dynamics. Each complaint had been dismissed with similar justifications. Rashad didn't editorialize. He let the testimony stack, one after another, building weight through repetition. The defense tried to distinguish each case, different circumstances, different contexts, different judgments made under pressure, but the cumulative effect was undeniable. This wasn't isolated. This was pattern. Angela Torres testified on day 7. Immunity agreement secured, anonymity waived, her decision to come forward framed as conscience over career. She described the quota system, the pressure to maintain numbers, the locker room culture that celebrated aggressive enforcement. The way younger deputies learn by watching senior deputies learning not just procedures, but attitudes, priorities, the unspoken rules of who to target and who to leave alone. She admitted her own complicity. She'd stayed silent when she should have spoken. She'd looked away when she should have documented. But she'd come forward eventually, when the evidence became too overwhelming to ignore. Whitman tried to paint her as disgruntled, opportunistic, seeking attention. Torres didn't take the bait. She said she was seeking accountability for herself as much as anyone. The internal affairs investigator testified next, confirmed Torres's account, presented the supervisor's handwritten log, the emails about arrest totals, the training materials that emphasized metrics over community relationships. Sheriff Gunderson testified on day 9. Rashad's cross-examination was surgical. How many complaints against Lumberfield and Luke had reached the sheriff's desk? 38. How many had resulted in meaningful discipline? 0. Why? Gunderson cited investigation processes, burden of proof, the need to protect officers from frivolous allegations. He said reforms were already underway: bias training, body cam audits, community oversight. Rashad asked when those reforms had begun. Gunderson said after the lawsuit was filed. Rashad asked if Mitchell's arrest had prompted internal review before the lawsuit. Gunderson hesitated, said he'd have to check records. Rashad didn't need an answer. The silence was answer enough. The jury deliberated for 11 hours across 2 days. When they returned, the forewoman, a retired schoolteacher named Patricia Nguyen, delivered the verdict without inflection. Liable on all counts: false arrest, civil rights violation, supervisory negligence. Damages: $850,000 to Mitchell, $200,000 to Cole, $175,000 to Hayes, $150,000 to Thompson. Punitive damages: $2.3 million against the county and sheriff's office, to be allocated toward mandatory reforms. The courtroom erupted. Not in celebration, the moment was too heavy for that, but in something between vindication and relief. Years of complaints dismissed, years of patterns ignored. Now, finally, acknowledged. Pamela sat still at the plaintiff's table, hands folded. She didn't smile, didn't react visibly. But when Rashad leaned over to ask how she felt, she whispered one word: accountable. Within hours, Sheriff Gunderson announced his resignation, effective immediately. No press conference, no statement beyond a brief letter citing the need for new leadership to implement reforms. The county board held an emergency session. They appointed an interim sheriff, a woman with 20 years' experience, a reputation for community policing, and explicit instructions to cooperate with the court-mandated oversight. The reforms began within weeks. Mandatory bias training redesigned from scratch, taught by external experts rather than internal staff, body cam footage audited monthly by independent reviewers, complaint processes overhauled to include civilian oversight at every stage, a community review board established with authority to recommend discipline, termination, policy changes, arrest quotas formally banned. Performance metrics shifted from numbers to community feedback, complaint resolution, de-escalation, success rates. The sheriff's office became a pilot program, a test case for reform that other departments would study, replicate, adapt. It wasn't perfect. Some deputies resisted. Some complained that oversight made their jobs harder. But complaints had always been part of reform. The question was whether institutions listened. Lumberfield faced criminal charges 2 months after the verdict: obstruction of justice for the email mistake that had exposed the tampering attempt, evidence fabrication for the altered reports. He pleaded no contest, received 18 months, eligible for parole after 12. His law enforcement certification was permanently revoked. In prison, he maintained that he'd done nothing different from any other deputy. He'd just been unlucky enough to stop someone with enough power to fight back. He never understood that the problem wasn't the power to fight back. It was the need to fight at all. Luke spent the year after his resignation teaching sensitivity workshops for a nonprofit that worked with law enforcement reform. He spoke to groups of officers, told his story, explained how easy it was to let bias guide decisions when procedures allowed it, when culture encouraged it, when no one held you accountable until it was too late. Some officers listened. Some dismissed him as weak. But he kept showing up, kept talking, kept trying to prevent other deputies from making the mistakes he'd made. It didn't erase what he'd done, but it was something. Pamela donated her settlement to 3 organizations: the Midwest Children's Cancer Foundation, a scholarship fund for minority law students, and a community legal clinic that provided free representation to people challenging wrongful arrests. She returned to the bench 6 months after the trial, resuming her full caseload. The recusal period had ended. The conflict was resolved. The work continued. She presided over cases with the same precision, fairness, and composure she'd always brought. She sentenced defendants who'd violated the law. She protected the rights of defendants who'd been treated unjustly. She didn't think about Lumberfield or Luke unless a case required it. They were footnotes in a larger story, actors in a system that had finally, slowly, begun to change. On a warm afternoon in late May, Pamela drove I-94 west toward a speaking engagement at the Children's Cancer Foundation's annual gala. The same route she'd taken a year earlier. The same highway where blue lights had flashed behind her. This time, no one stopped her. The patrols were reformed. The quotas were gone. The oversight was real. Progress wasn't perfection, But it was progress. And sometimes, Pamela thought as she exited toward downtown Minneapolis, progress was enough. The Hennepin County Oversight Board held its inaugural meeting on a Thursday evening in September, 7 months after the verdict. 19 members, community activists, retired judges, civil rights attorneys, religious leaders, 2 former law enforcement officers who'd advocated for reform gathered in a renovated community center that smelled like fresh paint and possibility. Pamela Mitchell sat in the front row, invited as keynote advisor. She'd declined a permanent board position, citing judicial ethics and time constraints, but she'd agreed to consult during the foundational phase, lending credibility and institutional knowledge to a process that needed both. The interim sheriff, Rebecca Alvarez, addressed the board first. She presented data, arrest patterns over the previous 6 months, complaint statistics, body cam audit results. The numbers showed measurable change. Arrests down 23%, complaints down 41%, use of force incidents down 38%. Community satisfaction surveys showed cautious optimism. Trust hadn't been rebuilt overnight, but the trajectory was upward. Alvarez didn't sugarcoat the challenges. Budget constraints, limited training expansion. Some veteran deputies resisted the oversight mechanisms, viewing them as adversarial. Recruitment had slowed as prospective candidates worried about increased scrutiny. But the reforms were holding, the culture was shifting, the department was becoming something different, not perfect, but accountable. Pamela listened without interrupting. She took notes. When Alvarez finished, the board members asked questions detailed, probing, the kind that revealed they'd done their homework. One member, a community organizer named Jamal Stevens, asked about long-term sustainability. How would they ensure reforms lasted beyond the immediate aftermath, beyond the attention cycle, beyond the current leadership? Alvarez looked to Pamela. Pamela stood. She spoke for 12 minutes. She talked about systems versus individuals, how reforming individuals was necessary but insufficient, how real change required embedding accountability into structures that outlasted any single person's tenure. She discussed codifying oversight procedures, making them legally binding rather than discretionary. She emphasized transparency, publishing data, making body cam footage accessible, ensuring complaint processes were visible to the community. She ended with something her father had told her decades ago. Trust is earned slowly and lost quickly. Systems that forget that fail. The board approved its initial framework by unanimous vote. Monthly audits, quarterly public reports, annual reviews with community input, binding recommendations to the sheriff's office for disciplinary action when violations occurred. The meeting adjourned at 9:47 p.m. Pamela drove home through streets where patrol cars still circulated, but the presence felt different now. Less predatory, more present. She thought about how change always felt fragile in its early stages, how easy it would be to slide backward, how vigilance was the price of progress. But for tonight, vigilance was working. Justin Lumberfield was released on parole after serving 13 months. He emerged from the correctional facility on a cold November morning, his former wife waiting in the parking lot to drive him to the halfway house where he'd spend the next 6 months. They didn't speak during the drive. He'd lost weight. His hair had gone prematurely gray. He looked older than 43. The halfway house was crowded, underfunded, staffed by overworked case managers who processed dozens of parolees weekly. Lumberfield attended mandatory counseling sessions. He worked part-time at a warehouse, loading boxes, avoiding conversations, keeping his head down. He applied for 3 security jobs. All 3 ran background checks. All 3 declined to interview. His parole officer suggested retraining, social services, community outreach, fields that might value his experience if he demonstrated genuine rehabilitation. Lumberfield didn't see the point. He believed he'd been made an example, not because he'd done anything uniquely wrong, but because he'd been unlucky enough to stop someone powerful. He never applied for the retraining programs. He never sought rehabilitation. 5 years later, he'd be working in warehouse logistics, still believing the system had failed him, never understanding that he'd failed the system first. Edward Luke's trajectory diverged sharply. The workshops he taught expanded from occasional sessions to a permanent position with the Minnesota Peace Officers Standards and Training Board. He developed curriculum modules on implicit bias, de-escalation, community engagement material drawn from research, best practices, and his own failures. He wasn't naive about his role. He knew some people saw him as someone trying to rehab his reputation. He knew activists questioned whether someone who'd participated in systemic bias could genuinely teach others to avoid it. But he showed up anyway. He told his story without softening it. He explained how easy it was to let prejudice guide decisions, how institutional culture could normalize bias, how accountability had to be more than abstract policy. He guest lectured at police academies. He consulted with departments implementing reform. He met with community groups, listening more than speaking, absorbing criticism without defensiveness. 3 years after his resignation, he was invited to speak at a national conference on policing reform. He shared the stage with activists, researchers, former officers who'd become whistleblowers. During Q&A, someone asked if he'd forgiven himself. Luke paused, shook his head. He said forgiveness wasn't his to grant. He'd harmed people. Mitchell, Cole, Hayes, Thompson, dozens of others who'd never filed complaints, but had driven home from traffic stops feeling degraded, violated, less safe than before. What he could do was work. Document patterns. Teach younger officers. Build systems that might prevent others from making his mistakes. He couldn't undo the past, but he could reduce the probability of similar futures. That was enough. It had to be. Pamela Mitchell's speaking engagements multiplied over the years following the verdict. The Children's Cancer Foundation invited her annually. Legal organizations requested her insights on judicial ethics and systemic accountability. Universities asked her to lecture on civil rights litigation. She accepted selectively, prioritizing events connected to causes she cared about, cancer research, legal education for underrepresented students, community justice initiatives. The scholarship fund she'd established grew beyond her initial contribution. Alumni donated, foundations matched. Within 5 years, it had supported 37 students through law school, each one from a background traditionally excluded from legal education. Pamela met with the scholars when their schedules aligned. She offered mentorship, career advice, references. She told them about her father's hands on that station wagon, about law school while working nights, about the long path from outsider to insider to someone who could change the system from within. She told them the work would be hard. The progress would be slow. The pushback would be constant. But systems changed when good people refused to accept the unacceptable, when documentation met determination, when patience aligned with principle. One scholar, a young woman named Keisha Ramos, first-generation college graduate, who'd grown up watching her community over-policed, asked Pamela if the fight ever felt futile. Pamela considered the question carefully. She thought about that holding cell, the missed fundraiser, the months of litigation, the ongoing vigilance required to maintain reforms that could erode with bureaucratic inertia. She told Ramos about a case from early in her judicial career. Domestic violence. Defendant violated protective order repeatedly. Victim kept dropping charges. Caught in cycles of fear and hope, Pamela had sentenced the defendant to mandatory counseling, community service, supervised probation. Months later, the victim had sent a letter thanking Pamela not for the sentence itself, but for treating the situation as serious, for believing her when others had dismissed her fears. One person, one case, one moment where the system worked as designed, that was what sustained the work. Not the dramatic victories, but the accumulation of small moments where justice functioned, where accountability held, where someone who'd been dismissed found themselves heard. Ramos nodded slowly, took notes. Years later, she'd graduate summa cum laude, clerk for a federal appellate judge, and eventually join a civil rights litigation firm where she'd represent plaintiffs challenging police misconduct. She'd remember that conversation, that measure of success, that definition of enough. On a bright afternoon in late autumn, Pamela drove I-94 west toward her judicial chambers. The same highway, the same route. 5 years after the arrest that had tested everything she'd built. The patrols she passed were different now. Body cams visible, oversight real, training reformed, culture shifting incrementally, the way cultures always shifted slowly, unevenly, requiring constant vigilance. She presided over 2,847 cases in those 5 years. Each one mattered. Each one required the same precision, fairness, impartiality she'd brought since her first day on the bench. The Mitchell case was history now. The reforms were policy. The oversight board was institutionalized. Life continued. Work continued. Justice, imperfect, slow, procedural, continued. As Pamela exited the highway, passing patrol cars that no longer made her pulse quicken, she thought about her father one more time, about promises kept, about systems changed, about the long arc that bent not through spectacle, but through method, not through revenge, but through accountability. She'd made things different. Not perfect, but different. And different, she'd learned, was where progress lived. She parked in her usual spot at the courthouse, gathered her briefcase, and walked through the security checkpoint where the marshals greeted her by name. Another day, another docket, another opportunity to make the system work the way it was designed. Pamela Mitchell climbed the stairs to her chambers, her mother's pearl earrings catching the afternoon light, and prepared to do exactly that. The work, as always, continued.
If you like this video, make sure to hit that like button, subscribe, and turn on the notification bell so you don't miss the next story. Share this video with someone who would appreciate it, and let's keep building this community together. And before you go, drop a comment below. I'd love to hear your thoughts on what stood out to you the most. Until next time, stay safe, stay curious, and I'll see you in the next one.